The Sarah Boone case has been a complete mess from the get-go, with even more bizarre new details to dish. From her behavior in jail to her answered want ad, this sounds like something you'd see right off of QVC, and even an odd new interview and a random law firm filing. If you're new to this case, be sure to check out my last video to get a full overview. Sarah Boone has been charged with the alleged murder of her boyfriend George Torres and is currently awaiting trial, and Sarah maintains that she is innocent of murder and says George just died as a result of hide-and-seek gone wrong. During the investigation, authorities uncovered 2 videos on Sarah's phone where she recorded her boyfriend stuck in a suitcase pleading for help as she laughed and mocked him, and she was quickly charged and is awaiting trial. But it doesn't stop there. Since then, she has gone through 8 different lawyers, with the judge pre-warning her that she would have to represent herself if the 8th lawyer didn't work out. And of course, with her pattern and history of challenging behavior, lawyer number 8 didn't work out, and she was informed that she would have to represent herself due to her difficult behavior. Or will she? I'm Linda with Itsacrime, so now let's get into it. After going through 8 different lawyers for a short time, Sarah did in fact represent herself. A hearing took place on July 26, which was scheduled by the court just the day before. She told the judge, "I am thoroughly confused," stating that she was unaware of the court hearing, and she continued to say, quote, "If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing it like it is for the second time?" And the judge responded with, quote, "Ma'am, again, this is why there were benefits to being represented by counsel. The court has already identified the reasons why you no longer have those benefits. It makes things exceptionally more difficult, which I explained to you in communicating with the court and communicating with the state's attorney's office." And ever since Sarah was informed she would be pro se, she has written numerous long letters to Judge Kranick. She even resorted to creating her own handwritten advertisement of inmate seeks lawyer looking for lucky number 9. Included in this ad were words such as looking for a prosperous challenge or ready for your close-up on national television. Are you zealous with the side of keen? Show the world who you are. And she lists the qualities she's looking for along with the words of epic, opportunity awaits, and ending it with invest in the oppressed, believe. And many were under the impression that no lawyer would take Sarah up on her offer given her previous history of behavior. Well, as it turns out, someone saw her ad and did take her up on her offer. Private attorney James Owens filed a notice of appearance to take over Sarah's defense on Friday, August 30th. And James Owens claimed he decided to represent Sarah after seeing media coverage of her case. He even said that he watches true crime on YouTube. Hi, James. You got to see this attorney's interview. More on that in a minute. He explained that he had initial reservations taking on Sarah's case, but they were able to work out their differences. He said, quote, "I think Sarah feels good about it now because she realized representing herself is harder than it looks." He goes on to say, "She hired me, she retained me, I plan on seeing it through, and I'm determined to help her see it through." So James Owens also then filed a motion to delay the planned October 7th trial, stating he needed more time to prepare a proper defense, and in his motion he hinted at the route they'd planned to take. He claimed he needed longer to prepare Sarah's defense and retain experts for a battered spouse syndrome defense. And speaking to reporters after the hearing, he brought some doubt to his planned route of defense.
Speak a little more to your plan for defense about the battered spouse syndrome.
Well, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think you all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days. So I'm going to try to pay for Dr. Julie Harper to fly down here
Now, it seems as some of the things that he spoke to reporters about completely contradicted things he had said shortly before in the actual court hearing. If he does not plan to use this defense, then what defense will he take? And what is battered spouse syndrome? Well, it's a syndrome that's considered by mental health professionals to be a subcategory of post-traumatic stress disorder, or PTSD. It's typically caused by domestic abuse that is usually from an intimate partner, but it can also be caused by others close to the victim, such as parents, siblings, grandparents, etc., and it tends to follow a cycle of abuse. First, the abuser will create a strong bond with methods such as love bombing, pressurizing, and grand romantic gestures. A relationship and commitment will also be rushed. Side note, I know in the dating world there is a lot of this going on. Comment below if you are also in that dating world and you see this. And secondly, the abuser will start out with smaller acts of abuse, such as punching something next to the victim, kind of testing the waters and desensitizing. And then the abuser will show guilt over their actions and pull out all the stops, making all the promises to change in an effort to win the victim back. Then once their efforts pay off, there will be a brief honeymoon period and they will be extra loving, extra attentive, caring. This lures the victim in to a false sense of security, often believing that they've really changed. And the physical and emotional abuse starts off small again and then builds, starting this cycle over and over, and rinse and repeat. And the victim will feel trapped into the relationship, unable to leave. There are many reasons why a victim might feel unable to leave the abusive relationship, such as being financially dependent on the abuser, where the abuser will often take steps to ensure that the victim is financially dependent on them, and this makes the victim less of a flight risk. And also wanting a family unit. If children are involved, it is common for abused women to fear the impact of a relationship breakdown on the children, and being afraid of their abuser is also something huge. Sometimes abusers will threaten the victim if faced with the possibility of them leaving, and the victim may fear backlash. And also, the victim being depressed due to the abuse can often leave victims believing it's their fault or that in some way they deserve it. There are many implications of this battered spouse syndrome. It can often lead to mental health problems such as depression, anxiety, PTSD symptoms, including dissociative states and violent outbursts against the abuser. And this could likely be this angle that the defense will take during Sarah's trial. And I'm betting that while you're watching this video, if you put a comment simply down in the comment section saying, yes, it's because you've either gone through this or you know someone close to you who has. And it'll be pretty eye-opening just to read the comments and see how many yeses you see. As for Sarah, taking into account that it's very likely Sarah's last chance to have legal representation, you'd think that she would be on her very best behavior. However, in true Sarah's fashion, not long after her new attorney was appointed, some cracks have already started to show. Inmate behavior notes from August 26th show some sort of altercation between Sarah and James Owens, and a correction officer noted that they heard yelling and loud yelling coming from the hallways. And after investigating, they realized that the yelling was coming from a briefing room where Sarah and this attorney were having a meeting. And because the yelling was causing a disturbance, the corrections officer had to enter the room and tell them they're being too loud. Sarah had apparently told the officer that everything was fine and they were just having a little disagreement. And the officer must have had some concerns about the situation, because after the meeting had finished, the officer spoke to Sarah about retrieving a grievance form. And Sarah told the officer that she didn't need one. Clearly, though, Sarah hasn't really learned from her past mistakes with her outbursts. It is interesting that the officer offered to give Sarah a grievance form to complete. And a grievance form is just a single-page form where inmates can outline their concerns and a preferred resolution. And the issue is then investigated. Typically, this involves calling or emailing the person the issue is related to see if the problem can be resolved. And once the investigation is complete, It is then signed off and returned to the inmate. Now, side note, in the case of Leticia Stoke, who was convicted of murdering her 11-year-old stepson, she had several types of grievances, and most of them being absolutely ridiculous. Do you remember this? Let me know below, because Leticia filed a lawsuit against both the county and the medical and food providers of the jail. And she said that the staff labeled non-kosher food and kosher food wrongly, and they violated the requirements. And then she said because she submitted these complaints that she was denied her food or they delayed it. And she also complained that she didn't receive medical treatment, but perhaps the most ridiculous was about peanut butter. In a letter to the judge, Judge Gregory Werner, who's amazing, she wrote, "Over 15 plus times I have been abused in transport, ranging from injured ribs, knot on my head, several ankle and wrist bleeding, bruising on my knee and my cell, loss of feeling in my hands several times." Side note, she actually assaulted an officer during transport. So it's boohoo for Leticia. She goes on to say, "I've had to be on insured 2 weeks due to the poison comments. And just recently on August 11, 2020, I received threats in my peanut butter because I provided evidence of not only my innocence, but evidence that will show who it was through my PI. As a result of this, I assume the runners use people in trusted positions in jail to send me threats in my food, and I'm terrified of what will happen next." Leticia was sentenced to life in prison, and her behavior in court was atrocious. She even at times gave the finger, and I think Sarah's behavior could potentially be interesting as well. And with this new lawyer, they do make a bizarre but interesting team. As for the disagreement between Sarah and this ninth lawyer, this is interesting. It's almost suggesting that maybe Sarah wasn't the only one involved in the yelling from the sounds of it, but maybe Sarah has met her match with James Owens. With little information, though, it's obviously difficult to tell at the moment, but it will be interesting to see if any more of these disturbances occur in the lead up to the trial. What do you think? And I'm confident, though, there will be more behavior notes. We still have some time. And it's been reported that Sarah has met with this lawyer 4 times in August. And during these meetings, Sarah apparently informed her defense that potential exculpatory evidence stored on her phone, which is currently in possession of the Orange County Sheriff's Office. This was mentioned in the new motion and reportedly includes photos, videos, calendars, notes, texts, and contact information for witnesses, all of which apparently support this battered spouse syndrome defense. Now, if we rewind a little bit, in June of this year, when Judge Kranick ruled that Sarah will defend herself at trial as she had waived her right to court-appointed counsel through her behavior, the judge firmly stated that the trial will not be postponed again and will start October 7th of this year. He said the trial will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. So we'll see if the judge changes his mind or not. And in a really strange turn of events, a California law firm attempted to file a motion to dismiss the whole case. And Sarah's case is in the state of Florida, yet this Californian firm argued that Sarah's right to a speedy trial had been violated because of the ineffective assistance of her previous lawyers. And the motion claimed, quote, ineffective substandard state-provided attorneys should have made this request long ago, proving this as a fact. And unsurprisingly, the judge dismissed the motion as the law firm is not involved with the case in any way. Now, side note, it reminds me of Chad Daybell's trial where there was a ridiculous motion to dismiss, and I swear that the lawyer filing was actually on a whiskey tear the night before. Judge Boyce was furious on that. Do you remember that? I'll have that in the description box below or at the end of this video. Now, it's a good thing that Sarah's getting a new lawyer because at a previous hearing on August 14th, Sarah complained to the court, said that she felt she was unprepared for the trial. And right now, Sarah has a laptop to access information related to her trial, but this laptop does not have internet access, which she complains about. And Sarah explained to the judge that she blames her lack of internet access for not seeing briefs filed in her case. And during the hearing, jail officials testified that pro se inmates, or inmates who are representing themselves at trial, were not permitted to have access to the internet. She also urged the judge to close a scheduled evidence viewing for the media, and she complained that media outlets were exploiting her case for views and ratings, and Judge Kranick ruled that she failed to meet the burden required to close the viewing. Luckily for Sarah, though, prosecutors did offer an alternative option. They proposed that investigators could meet with Sarah at a law enforcement office to allow her to review the evidence without the presence of the media. And she was warned that she would not be allowed to touch any evidence, as obviously it has to be handled by the investigators. But Judge Kranick approved their proposition. Sarah was unhandcuffed during that hearing, allowing her hands the freedom to make notes. And as mentioned in my previous video, Sarah will be without handcuffs or leg shackles during the trial, but she will be wearing a more discreet stun cuff, and any wrong move, and she gets a surge of 50,000 volts to her body. Now, Judge Kranick asked Sarah if she had been, given any thought as to what she would like to wear during the trial, and Sarah told the judge she'd like to wear a skirt. He then warned her that if she chose the skirt, that the jury would be able to see her stun cuff. However, if she wore pants, obviously the jury wouldn't. In a motion, also, Sarah asked the court for money to pay for a neuropsychologist as part of her defense. Here's something also interesting. Behavior notes from the Orange County Jail details that on Sarah's last court appearance on that August 14th, it was discovered that, quote, Boone had altered her county-issued blues with staples along the seam of her pants. And the notes go on to say that Sarah was informed that the pants were now considered contraband, and she was reissued new pants. And it also states that she was, quote, counseled for this negative behavior. And then just 3 days later, after an interview with a professional visitor, notes claim that, quote, during the search, inmate Boone became argumentative and questioned staff why her property was being searched. I explained to inmate Boone that she is subject to search at any time inmate was not receptive. And behavior notes also show that Sarah has been using that laptop daily to review evidence while complaining that she doesn't have access to the internet. They also show that Sarah's been refusing meals and showers, and a corrections officer described her as having a patronizing tone. And she has been noted as frequently misrepresenting what was being said during conversations regarding access to materials in jail. She reminds me of Eileen Warnos. I mentioned that before in my previous video. It's just very interesting how there's a lot of little details that sounds like her. Now, Sarah appeared in court on Tuesday, September 3rd with her new attorney, James Owens, and her attorney requested that the trial be pushed back to the end of this year or the beginning of 2025, saying that they need to hire expert witnesses to help in Sarah's battered spouse defense. James Owens told the judge, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense because I don't believe my experts would be ready, so that's instrumental to our defense. And Judge Kranick stood his ground and said he just refused to extend the trial date anymore. He told James, Mr. Owens, it seems like you've already started diving into the case and what the court file has reflected. Also the YouTube videos, and acknowledging the trial has already been delayed for over 4 years. The judge also noted that James was fully aware of the trial and deadline dates when he decided to take on this case. The judge said, quote, when you undertook this assignment knowing that you were not being appointed and that by your own representation, you're doing this free of charge on a pro bono basis, not seeking compensation for any lodging or travel. You knew what the deadlines were for the court. He also said that Sarah only has herself to blame for her previous attorneys withdrawing from the case. To that I say, absolutely. Sometimes we see judges sweep some things, just to move the process along, but I'm glad he's given her a little bit of a tongue lashing. Now, in court, the judge said that James was doing this for free for Sarah, but in his interview, in his 12-minute interview, he said that Sarah's actually paying him.
Are you doing it pro bono?
I've been retained. I'm not doing it pro bono.
Who's paying for it?
Sarah owes me. Sarah owes me.
And he filed 2 motions also during that hearing. In the first motion, James requested the assistance of a crime scene reconstructionist/death investigator to assist in Sarah's defense. And he requested the court appoint Dr. Brannon, who just recently participated in the trial of Marcia Thompson, who was charged with the murder of her husband. And she claimed that she and her husband Terry got into an argument in August of 2019 where he threatened to slit her throat. And she claimed to have shot him in self-defense. But eyebrows were raised when officers discovered that Terry had 6 bullet wounds to his body and 9 fired bullet casings in the living room. And her defense claimed that she was a victim of battered spouse syndrome. And Dr. Brannon diagnosed Marcia Thompson with battered wife syndrome and testified in her defense at her trial similarly to Sarah's case. And in July this year, she was found not guilty of first-degree murder in the shooting of her husband. Now, in the second motion, Owens also requested the court appoint forensic psychologist Dr. Harper to aid in her defense. Attorney James Owens spoke outside the court after the hearing in this 12-minute interview, and speaking on his unsuccessful motion, he said, "I'm going to have some help." He said, "I'm trying to assemble a team right now." He also told reporters that he tried to negotiate a plea deal with prosecutors.
So we did make attempts, like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations. That's just part of it. So there were attempts to settle it. I was kind of like a mediator. I was kind of like a go-between, because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate with the prosecutor, trying to send her to prison for the rest of her life. So somebody had to do it. I was doing it.
Now, Sarah is next due in court for a motions hearing on September 26th with her new attorney by her side, if he lasts that long. And her trial is due to start on October 7th and is expected to last for 3 weeks. Will you be watching or interested in watching this trial? I will be here for it. If you want to check out that video of Judge Boyce being super angry, check it out here, and check out the playlist on the Sarah Boone case.